The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning, everyone. We are here for oral arguments in CR21 0329, State versus Valdez. As you probably know, we record and live stream our proceedings, so when you get up to speak, if you would please announce your name and the client that you represent. You have a maximum of 20 minutes per side. You are not required to use all of that time, but we do require you to keep track of your time, especially if you would like to reserve time for a rebuttal. Please keep in mind, we've read the briefing, we have reviewed the record, and we have conferenced the case. With that, please feel free to proceed.
Good morning. May it please the court. My name is Michelle DeWalshy. I'm with the Maricopa County Office of the Legal Advocate, and I represent the appellant, Efrain Olawe Valdez, in this matter. I do intend to try to reserve about 3 minutes for rebuttal, and that's all. The constitutional right to an appeal is illusory if a trial judge refuses to investigate credible claims of juror misconduct and bias, thereby leaving the defendant with an inadequate record for meaningful appellate review. The Sixth Amendment right to a fair and impartial jury is illusory if a trial court arbitrarily denies a motion for additional voir dire to root out potential prejudice in specified and identified potential jurors. In this case, the trial judge's failure to conduct any investigation into the juror misconduct was an abuse of discretion. The denial of the additional voir dire, and it was a timely request for voir dire, was also an abuse of discretion. Further, the court's failure to even notify the parties of the first instant of reported misconduct is essentially left a seated juror, juror number 3, who the court had reason to know had bias, on the jury for an additional 9 days. On this record, this court cannot be confident that the verdicts that were rendered are surely unattributable to the error. I would like to begin with juror misconduct, if the court will allow me, and there are really 3 parts to this argument. The first is, as mentioned earlier, the failure to notify the parties of the initial report by juror number 2 of juror number 3's bias. And the bias was, I know you've read the briefings, derogatory comments to defense counsel. Now, the court under Rules of Judicial Conduct 2.9 has an obligation to promptly notify the parties of any ex parte communication. And if you look at cases like State v. Bible, and it cites also State v. Mata, this type of communication from jurors, if it's substantive to the case, is considered ex parte communication. The court's failure to notify the parties basically deprived defense counsel from the opportunity to object and to request an appropriate remedy and request investigation into the extent of the bias and the effect it may have had on the other jurors. Further, I apologize.
Can you back up just a second? What do you mean by it was an ex parte communication? How was it ex parte? Are you saying it was extrinsic to the jury? It didn't come from outside the jury?
It did not come from outside the jury, but there are very similar cases in Arizona. I'm citing State v. Mata, which is cited in State v. Bible. And I will, give the quote in State v. Bible. It was considered ex parte communication, and they said it was improper for a trial judge to communicate with the veneer unless the defendant and defense counsel have been notified and are given the opportunity to be present. That did not occur in this case. There was a communication to the bailiff.
That would be communication from the court to the veneer.
Well, yes, Your Honor, I agree. And the court did instruct his bailiff to tell juror 2 that to tell juror 2, just let us know if it happens again. And so I would, assert that is an ex parte communication. Further, so the court's failure to exercise discretion and investigate this colorable claim of misconduct and to notify the parties was an abuse of discretion. And really, that first instance even robs Mr. Olawe of his right to a Rule 32 ineffective assistance of counsel claim. Because if counsel did not know about it and could not object to it, then there is no ineffective assistance claim. So for that reason, this should be addressed by this court. So not only does, the failure to notify the parties not allow counsel to ask for an appropriate remedy, but it also robs Mr. Olawe of that right to Rule 32 relief on this issue. And finally, the court admitted its error. And so if you look at the transcript from June 11th, 2021, at pages 16 to 17, the court, in deciding to reverse course and grant the second motion for a continuance to allow defense to conduct its independent investigation, the court says, I'm doing this because that was on me. It was my fault. My failure to notify the parties resulted in Juror 3 remaining on the jury. And so the court's failure to even investigate at all, conduct an evidentiary hearing, ask questions of Juror 2 or Juror 5, or even call Juror 3 back in to ask questions at that point was an abuse of discretion, especially given his acknowledgement of his error. Next, the second part of that argument is the failure to grant the motions for mistrial and a new trial, or in the alternative, to question Jurors 2, Juror 3, and Juror 5 regarding this incident. So Jurors 2, 3, and 5, I think clearly violated Rule 18.6 of the Arizona Rules of Criminal Procedure, which is to follow the admonition, and also the Rule 19.3, which is forming and expressing an opinion about the case before all the evidence is in. Juror 3 clearly expressed an opinion about defense counsel, and this occurred according to the bailiff, and this is the only record that we have, as soon as defense counsel stood up to make an opening statement on the first substantive day of trial. And so Juror 3 also violated Rule 19.3. So questioning was warranted. There's no indication that the judge did not think this was a credible allegation. Clearly, he must have, if it was his idea and his suggestion to dismiss Juror 3 after the second report of the bias. And so I think that this court can consider this a credible allegation of misconduct.
I agree with you that the statements by the juror clearly indicate a bias against counsel. Is there support in case law, or maybe there is or maybe there isn't, but is there support in case law for the proposition that expressing disdain for counsel is the same as forming an opinion about the case?
Well, we don't have a case on point in Arizona, and so I think the closest we have is a case cited by the state v. Dietrich, but that was a defendant basically on appeal saying that he was prejudiced by disparaging comments about the prosecutor or about plaintiff's counsel. No, it was the prosecutor. And so in that case they held, well, there couldn't possibly be prejudice. In this state, we have not, the courts have not addressed this issue. And, the bias against defense counsel, as I said, it was from the very beginning of trial, and I would ask this court to at least impute it to the defendant, especially on this record, where we don't know the extent of that bias, and we don't know whether or not that extended to the defendant because the court failed to conduct an investigation.
I understand and agree with your argument that the trial court should have done more, especially early on. On this record, though, and I get the kind of catch-22, on this record, though, what is there that we can look at to say your client was prejudiced at all?
Well, Your Honor, I believe in a case like this, prejudice may be presumed. And so I know that Arizona...
And I get that, your argument, but how can we presume any prejudice from this? The only comment was from Juror 3 that we know of. He did not deliberate or did not take part in the deliberations, and the only record indication we have is that Juror 2 heard him and was upset by him. So it's doubtful that he it seems the presumption would be that his comments didn't serve any purpose in that regard.
Well, I would assert that the fact that the juror 3 clearly continued to make disparaging remarks, and I know that we are presuming that nobody else heard it because they didn't report it. But again, if there were an investigation, we would know that. I think on these facts, the fact that it was allowed to continue for 9 additional days, the fact that even juror 2, after the response from the court after first reporting it, was uncomfortable coming forward and discussed it with juror 5, we know at least there was that communication about these comments. We don't know the extent, and if we don't know, that's my alternative request, is that this be remanded to the trial court to conduct that evidentiary hearing that should have been conducted in the first place.
To what extent, assuming, and I don't know that we're there, but assuming that we don't presume prejudice, or even assuming we do presume that there's maybe a possibility of prejudice that we should consider, how much does the strength of the underlying case factor in, if at all?
Your Honor, what I would ask, and I know in Arizona only cases involving extrinsic evidence have been trigger that presumption of prejudice that requires reversal, or at least remand for an evidentiary hearing. However, the rule is not that if prejudice is proven or if extrinsic evidence has been proven. The rule is prejudice or if it may be fairly presumed from the facts of the case. And my argument to you is that from the facts of this case and this record, that prejudice must be fairly presumed and that this must be remanded at the very least for an evidentiary hearing and preferably for a new trial.
So your position would be that the strength of the underlying facts of the case don't weigh into an analysis at all?
Yes, Your Honor. If the court presumes prejudice, then I would think that the strength of the case really doesn't factor into it. But I would also point out that in this case, although there was, DNA evidence, Mr. Olawe lived with one of the people, the occupants of the Jeep. His mail in the vehicle, his DNA on, beer bottles in the vehicle would have been expected in this case. There were an additional shell casing that was found and no gun was ever recovered. There were inconsistent eyewitness accounts of a man with a gun, without a gun, with a hat, without a hat, tall, short, dark-skinned, light-skinned. All of these were inconsistent. And the gun that was used in the shooting was found at the scene. And so I would submit that the facts in this case are not as secure as, or overwhelming as the state would lead you to believe. I also want to go back to, I apologize. In Smith v. Phillips, the court determined that the investigation into juror misconduct must be reasonably calculated to resolve the doubts raised about the juror's impartiality. That did not occur in this case, and so the judge, I do believe, failed in his duty to investigate the misconduct and formulate the appropriate remedy at every step of the way.
But in that case, didn't that juror actually participate in the decision?
Yes, and I would say to this court, juror 2, we know, did deliberate in the decision, and that leads me to the third part of this, which is...
Is there any inference or even presumption that we should apply to suggest that we could apply to suggest that juror 2 was biased?
Well, juror 2 did hear the comments, we know at least twice, maybe even more
about them
during trial, and did complain about them. However, without any questioning whatsoever, we don't know the impact that it had on juror 2, and we don't know the extent that juror 2 discussed it with other jurors.
That's where I get hung up, is I get the idea of the presumption. If juror 3 had deliberated, this is an easy reverse. But we have juror 2 who complained, juror 5 who presumably... not even presumably, was complaining as well. The only indication in our record, I don't see how we get to a presumption of prejudice when those two, the only two that we know of that heard the statements, complained about them, and how do we presume that there was any bias on their part?
And, Your Honor, the alternative argument is if we can't presume, if this court is not comfortable presuming prejudice, then the answer is we don't know the extent of it, and therefore this should be remanded for an evidentiary hearing to ask the jurors about what extent they were affected by or even exposed to Juror 3's bias. And then the third part of that juror misconduct question is when three deliberating jurors, left the deliberation room to inform the bailiff that they were being excluded from deliberations. The court did notify the parties, however, decided to do nothing, let them take a break, and not ask any questions of the jurors. In State v. Rojas, this court actually condemned the trial judge for doing the same exact thing and waiting until after the verdict to conduct an investigation. The court reversed in that case and remanded because they found that the court should have, I apologize, let me get it, the court should have, basically the proper procedure was to stop deliberations, pull out the individual jurors, and to question them individually about what was happening and to determine whether or not there was actual intimidation occurring. That procedure was actually affirmed by the Arizona Supreme Court in State v. Coleman, where you had a similar situation, and what happened is the judge stopped deliberations. He advised each of the jurors before questioning, don't talk to me about your mental processes, don't talk to me about the deliberations, I want to know what's happening with the intimidation. And the court approved of that and affirmed what the trial court had done in that case.
You seem to have skipped a step. We have a allegation from three jurors that they were not being allowed to deliberate, and now you've talked about intimidation. What is the record here that we say intimidation?
Well, the record is that, well, first of all, it wasn't one, it's three.
In Coleman, there was intimidation, there was an allegation of that. So what is our allegation here?
Well, the allegation of three jurors, not just one, to actually remove themselves from deliberation and to appeal to the bailiff for some sort of guidance saying, look, we're being excluded, and for the court to not have asked any questions there, I think that you can assume that there may have been
That's
intimidation.
the same as intimidation?
Well, if they're being excluded and we don't know why they're being excluded, is it because other jurors are threatening them? Is it because, they...
Again, where's anything in our record that we can point to? And Catch-22 recognized, but where's the record or any suggestion that there was intimidation, threats, coercion?
Well, I think the suggestion is the fact that three jurors felt that they had to leave deliberations to alert the court to the fact that they were being excluded. We don't know what that exclusion was, and so I would say, the proper procedure there would have been to stop deliberations, question them further, and just, make sure and put it on the record whether or not there was, in fact, intimidation. And in this case, unlike in State v. Rojas, the court didn't even conduct a post-deliberation investigation, so we have no idea what the issue was where the jurors were feeling excluded. Your Honors, I would like to save the rest of my time for rebuttal. Thank you.
Thank you for your argument.
May it please the court, Eliza Ibarra for the state. This case represents an archetypal exercise of a trial court's discretion. And the standard of review is very, very important here. This court is not being asked to look at this situation de novo and say what it would have done if it had faced these circumstances, or create a list of best practices for other trial courts to do under any conceivable situation. Instead, under the abuse of discretion standard, the only relevant question is whether the court's decision was manifestly unreasonable or exercised on untenable grounds for untenable reasons. And this comes straight out of the opening brief on page 18, and they're quoting the Sandoval case. So under this standard, the fact that the trial court could have done something slightly different does not mean that it abused its discretion in doing what it did. Under this high standard, there's nothing reversible in this case. And I'd like to pick up where the court left off with the 3 jurors who stepped out.
How is it tenable for the trial court not to have notified the participants or the parties upon the first complaint?
Well, certainly the court had an obligation to notify the parties, but the court did that. And the fact that it happened days later was inconsequential. It was technical error at best.
Why is it inconsequential that this was allowed to continue for 9 days?
Well, because Juror 3 was removed. We have no evidence that anybody else heard Juror 3's comments. We know that Juror 2, who heard them, was offended by them.
But she, or he or she shared that with Juror 5.
Actually, we know that Juror 5 did not know what the substance of the comments were, but it doesn't really matter because Juror 5 was removed too, because Juror 5 was an alternate. So what we have here is a situation where there was no possible prejudice, even assuming error.
But we're assuming for 9 days that jurors don't speak to each other. Is that the assumption? That jurors just don't speak to each other when they're on breaks, that they don't communicate, they don't chit-chat?
No, I mean, I think jurors do communicate with each other, but I think what we don't have here is any reason to think that they were talking about the substance of the case or innocence or guilt or anything that involved extrinsic evidence.
Does the derogatory remark, is that involved in your mind, is that about the substance of the case?
Well, that derogatory remark was absolutely improper, but I don't think it was about the substance of the case. I think any of the jurors who heard it would probably have been turned off by it because most people don't really like profanity or disparaging comments. So it was much more likely that if they heard this, they would just think, oh, what a jerk, I'm not listening to him, and he just lost any influence he might have. It just doesn't follow that if another juror heard him say that the other juror would think, okay, well, Juror 3 thinks that defense counsel is a dumb bee. So I like Juror 3, so that means defense counsel is a dumb bee. Like, no reasonable person would ever jump to that conclusion. It's far more likely that the jurors simply were turned off by it if they heard it, and there's no evidence that any other juror heard it. We know that the one juror who did hear it was offended by it, Juror 2.
I want to walk through this a little bit because I think I understand your argument, but I want to make sure I'm clear. The court, your position is the court didn't abuse its discretion because ultimately it told defense counsel, or both parties, that this had happened.
Well, I mean, I think it certainly could have notified the parties sooner in an ideal situation, and I think perhaps it's easy for us in hindsight to say, well, this would be the best way to handle this, or this would be the best way to handle this. But I think that in the grand scheme of things, there was no abuse of discretion here because the trial court removed Juror 3, and all the parties agreed that that was the best solution when they first were presented with the
Earlier
option.
I said it was error, it was an abuse of discretion not to notify the parties. And you said, well, yes, but he ultimately told them. So the fact that he told them on day 9 means it wasn't an abuse of discretion. Maybe we could have done better, but he didn't. It wasn't so bad that we have to reverse.
Right, like I think the question facing the court is just whether you need to reverse on appeal. So, I mean, it may be that this court doesn't like what the trial court did. That's completely possible. But that doesn't mean that the trial court abused its discretion.
And I think the only reason the trial court ultimately notified him is because it got a second report. So wouldn't your argument then be that if there hadn't been a second report, it would have been fine to let that juror stay on the panel and go all the way to deliberation? I mean, I'm shocked, and I know Judge Fish and have a lot of respect for him, but I'm shocked that he seemed to think that, well, if we don't hear another complaint, it's okay. I don't know how we can kind of condone that type of decision.
Well, I mean, I think if this court were thinking in ideal circumstances, I don't think you have to condone it. And I do think that if the parties had never heard about this until after the jurors had started to deliberate, then it probably would have been an abuse of discretion because the court had an obligation at some point to tell the parties about it. And I think it's really up to the court.
Would you agree that if Juror
yes.
3 had made it onto the panel, we would presume prejudice and presume that this is reversible error?
Well, I think it would be a much closer case, but I still don't think that that would involve extrinsic evidence, and I think that the cases that presume prejudice always involve extrinsic evidence as far as I have been able to see. So I think you would still look at all the facts and circumstances and decide whether or not the trial court abused its discretion. I don't think that you would have a presumption, but it may be that this court would come out the other way if Juror 3 had sat on the jury.
Did you hear the questions I was asking your colleague about whether the strength of the case factors in?
Right.
What is your position on that?
Well, I found some cases where they said that it did factor in, and I think that the case of State versus Arias is sort of instructive. It's not exactly the same situation, but it's analogous. That was the case where Juan Martinez made a very inappropriate comment to, I think, defense counsel during a bench conference. I think what he said was, "If I were married to you, I would kill myself," or something like that. And everybody agreed that was a completely inappropriate comment.
I've
But
never
the
heard of
facts
this Arias case. Was this high profile at all?
right. But so the facts in Arias were so overwhelmingly guilty, any error would mean that it didn't matter. And I think that this court, when it's looking at the situation, first there was no error because Juror 3 was removed. There was no prejudice. We know that Juror 2 didn't like it, and that's the only person that heard it. We know that Juror 5 didn't sit. We know that, I'm sorry, going back to your question.
As you're talking
Okay.
about what we know, isn't that some of the problem here that your colleague identified? We're limited in what we know because the judge didn't do any investigation, didn't, conduct some sort of hearing or investigation into the extent that this went through the jury given that 9-day period. I mean, what is the impact of that? Do we, the catch-22 that your colleague is in, being tied to a record that is admittedly incomplete because we didn't have any investigation?
Right, we do live in an imperfect world, and all we know is what we have in the record. But
sometimes we have the opportunity to help and fix some of these things by sending them back for more exploration. So if you could talk to me about why there's no remand required to hold a hearing to garner these facts that we don't have. Might not be perfect then, but perhaps it could be better.
Sure. There was just no information that anything extrinsic had been presented to the jury. The trial court was in a position that this court is not. It would be inappropriate for us to second guess. The trial court knew exactly where all the jurors were seated, how they were facing, their body language, their participation during trial. That's not really apparent from this cold record.
In making his decision to exclude the juror and not do more, did he ever reference that? Did he ever say, I observed the jury, I read their body language, I know what was going on over there, and I don't think this had any impact?
Well, the court didn't say that it was doing that. There's nothing in the record, but I think certainly it probably influenced it in some way. And we do know from the record that they were socially distanced. Each juror was at least 6 feet apart. They were all spread throughout the whole gallery. They weren't all sitting in the jury box. All of the jurors were masked. When Juror 3 made the comments, he was muttering under his breath. And this proceeding had been completely plagued by acoustical difficulties throughout, and the jury had been extremely active and had asked approximately 300 questions total, which breaks down to about 30 questions per day, or approximately 2 questions per juror per day. That's an extraordinarily active jury. And so the court reasonably exercised its discretion and considered the atmosphere of trial in a way that we can't, frankly, from the cold record. And the Chiantese case that I mentioned also referenced this. It's just because these sorts of considerations are not apparent from these cold transcripts, it's always considered under abuse of discretion whether or not the trial court has to conduct further inquiry. And you might have done something different, and you might not like what the trial court did, But that doesn't mean that it was an abuse of discretion for the court to do what it did.
You talked about the focus on extrinsic evidence, and I get that, but isn't what we have here is a biased juror? I mean, any juror that says that is biased against defense counsel. Anybody that makes that comment, or you call it what you want, it's rude, it's unprofessional, but it's also biased. It shows a clear bias against the defendant. And so for the court not to take 5 minutes and pull that juror in and say, what's going on? Do you have a problem, sir? With what is going on? Or ask a question. It's like, have you met this person before? Do you still want to stay on this jury? I don't know. Just a couple of questions that would have added to something to the record to show, okay, it's all good. I don't know. I was just joking under my breath. I don't know. I mean, I shouldn't have said that. I'm very sorry. I don't really want to be here. It says and to leave somebody on that for 9 days with that stewing, it does seem problematic. It really does seem problematic. So I am struggling with the notion that the court just let it lie. Do you agree with me that it's biased, that juror number 2 was biased, at least showed that the term used shows a bias against defense counsel at a minimum?
Defense counsel, but I don't know that it necessarily translates to against the defendant. I think in 12 Angry Men, Henry Fonda also complained that defense counsel wasn't doing a very good job, but was a hero for the defendant in that case. And so I don't think we really know. And the reason why that's not a problem is because juror 3 was removed and did not deliberate. And I think, like Judge Moore said, if juror 3 had deliberated, it would be a much different case, and it might come out the other way.
If you got about 6.5 minutes left, I would like you to address your colleagues' arguments about the walkout, and especially whether or not the court erred in respect to not inquiring further.
Okay. It actually seems to me that the trial court handled this situation perfectly.
She cites 2 cases that says the trial court didn't. So why don't you tell us why her citations are inaccurate?
Okay, well, I think each case is very factually specific. But I think in this case, all we knew, and this
I'm sorry, I didn't mean inaccurate as in she was misleading or anything. I just meant why those cases aren't controlling.
Well, because in this situation, all we knew, she keeps saying that the jurors were excluded, but the actual quotation from the transcript when the bailiff is talking about this, the bailiff says, 3 of our jurors have stepped out of deliberations. That makes it sound like it was their choice. There was apparently a difference of opinion. That makes it sound like they were disagreeing about something which is totally normal while deliberating. I don't know on what, but they said they are not being allowed to participate with a larger group. And that statement is really ambiguous. We don't really know if the other jurors were feeling like they weren't being allowed to make all of their points. Were they just complaining that they didn't think that other people were listening to them? There's absolutely no reason to think that translated into a claim of intimidation. And I think the trial court wisely took a step back and said, well, if we come back from our break, like all of the other jurors had been sent on recess, if we come back and they're saying that they're being excluded, then there will be a problem, and at that point we will need to investigate. But the trial court didn't want to get involved until it actually knew there was a problem. And when they got back, all of the jurors were present, and that was noted in the minute entry for that day, and they all deliberated, and then later when they were polled, they all agreed that it was the true verdict. So there's just no reason to think that was an abuse of discretion for the trial court not to ask more questions. It said that it would have asked more questions if there had actually been a problem, and the jury was so active, it would really be shocking if there had been some kind of problem and those jurors didn't submit a question and they didn't say anything during polling about feeling pressured or intimidated to agree. So there's
those three
just...
jurors walk out in the middle of deliberations, or was it at the time of a break, and then they kind of separated themselves and went and talked to the bailiff?
It appears that they...
Or does the record not tell us?
Okay, so it doesn't seem like they were already on break. It seems like they stepped out. They went upstairs and told the bailiff. The bailiff immediately went downstairs and told everybody to take a break. And that's all on page 3 of April 7th, 2021. So I don't believe they were already in a recess when they came to the bailiff. I think they just stepped out for whatever reason. It seems like tempers had flared, and maybe after the break it dissipated the tension, and they were able to come back and deliberate. And 12 angry men, it's really not abnormal for jurors to disagree about anything when they're discussing a case.
So would your position be that this is equivalent if there had been a note passed to the bailiff that said 3 of them are standing in a corner and feel like they're being excluded, but they hadn't? I'm just trying to, it seems different to me when they walk out of the room, but I don't know why. So maybe you can tell me why it isn't different.
Okay, well, it does seem like if they were actually being bullied, they would have been forced out or physically kicked out or said, we're feeling intimidated, or followed up when they were being polled and said, I said that while we were deliberating, but that was just because I feared for my life, and I don't really believe that. And that's happened in other cases. The case I cited, coincidentally by the name of Olague, involved a juror who actually at the time of polling agreed that it was her true verdict, but then in post-trial proceedings submitted an affidavit that said that she felt physically afraid for her life, and that's why she switched her vote, and that's why she said everything was fine during the polling. But even under that circumstance, the court still found that the polling cured it and did not reverse. So I think that if you go and read Olague, you'll see that this situation, maybe this court would have handled it differently than the trial court did, but I think what the trial court did was a great idea, to not intervene until it became apparent that intervening was necessary, and I don't think it was an abuse of discretion at all.
Go ahead, I'm sorry.
Okay, I was actually going to say, if the court has no further questions, it seemed like maybe you had a question. Okay, so I don't think we really talked much about the denial of the motion for voir dire. But the important thing to remember about that motion is there was no nexus between the proposed additional voir dire and the allegation that Juror 3 did not like defense counsel. So it's totally speculative to think that if the court would have granted it, that somehow this bias would have become apparent. And if there are no further questions, the state would ask that this court respectfully affirm.
Thank you, counsel.
Okay. So I'd like to address just a few things that that my colleague mentioned. First is the State v. Arias. That comment was made at a bench conference, and there's no indication in that case that any of the jurors heard the comment. And so this is different because we do know that at least one juror heard it and was told about it, and another juror was told about it by that juror. So I don't think that Arias is really even persuasive here. I would point out that in State v. Olawe, so that's, or Olague, I don't know how to pronounce it, but it's a different defendant, same name, at least same spelling. In that case, this court actually put in footnote 3 that, even though in this case we are, considering the polling of the jury as part of the reasoning for our analysis to affirm and not reverse and remand, but we leave open the question as to whether or not the polling of a juror will always prevent reversal and remand. And so I would say that Olawe at least left that open. And in this case, we also had in the record that Juror 1, defense counsel said, well, Juror 1 seemed hesitant. And instead of questioning Juror 1, the judge just said, I think it was because he was the first one to speak and he just seemed like maybe he was surprised by it. And so, I would just point out that as far as Olawe and the polling, I don't think that that is necessarily dispositive in this case. Next, I would like to discuss basically, what the court's questions about what we know and what we don't know from this record. And I think, either this court may fairly presume prejudice based on the lack of the record and what we have in this record that indicates that the bias, may have been could have been heard by other jurors, or we just don't know. We don't know. And if we don't know, refusing to at least remand for an evidentiary hearing in this particular case deprives Mr. Olawe from a meaningful appeal. And so for that reason, I would ask that this court reverse and remand this case for a new trial, but at the very least to reverse and remand for an evidentiary hearing so that we can at least know that the bias did affect them or the bias did not. But the bias clearly was present from day one, and it continued for 9 days unchecked. And so I would ask for the relief requested in this case. Is that it? Okay.
Thank you, counsel. Thank you for your arguments. We will take the matter under advisement and issue our decision in due course. Court is adjourned.